Hello, my name is Cesar Pereira. I'm a partner at Justin Pereira Oliveira e Talamini in Brazil. And together with Mastrobono Advogados, represented here by my colleague Cristina Mastrobono, we're very happy to bring to you this discussion about Latin American parties in disputes in Asia, especially considering the experience of the Shanghai Arbitration Commission. It's very interesting to notice that we have here an extremely international panel. I'm going to introduce you our panelists, but I'm just very happy to point out that I am right now in the US, Cristina is in Brazil, Rajesh is in Australia, Minshao is in Shanghai, and we will be joined in a moment by Shirlin, who is in Hong Kong. And so among the five of us here, we cover 5 different countries just in this webinar. So it's a good indication of how international we can be at this time at this age in the world. Well, as I said, I'd like to first of all introduce to you our panelists here. Just a moment here. Shirley is just asking for a link here. Could any of you please just share with her the panelist link? So if you can do that. Meanwhile, I will introduce you to our audience. So I said my co-host here is Cristina Mastrobono. Cristina is a Brazilian attorney and arbitrator. She was an attorney for the state of São Paulo, which is the largest state in Brazil, responsible for maybe 1/3 or 25% of the country's GDP. She was an attorney for the state of São Paulo for 27 years, and now she has recently moved to private practice. She has an LLM from the University of Chicago, and she is one of the directors of the Chartered Institute of Arbitrators Brazil branch. We have here also Professor Rajesh Sharma. Rajesh is a professor at RMIT University in Melbourne in Australia. He has a PhD from the Chinese University of Hong Kong, and he's an associate director of the Hong Kong WTO Research Institute. And I'm very happy to say that Rajesh and I shared a course at the Swiss International Law School some time ago, and it was I was very proud to conduct that course with Rajesh. It was a great pleasure. And we also have here Minshao Fan. Minshao has a PhD from East China University of Politics and Law. He's the executive vice chairman of the Shanghai Arbitration Commission, and he's the chairman of the Arbitration Commission of the Chinese Football Association. So that's also a connection with our Brazilian team here. And last but not least, we have here Shirley Tung. I'm sorry here. I left one step out here, and that prevented Shirley from opening her camera, which she is doing now. Okay, good. So now we have Shirley Tung here with us. Shirley is a partner at Withers Worldwide in Hong Kong. She's a member of the ICC Dispute Resolution Bulletin Editorial Board, and she's a deputy director of the Vis East Moot Foundation. And she, that, as you can imagine, has been making her very busy for the past few weeks, and especially on this one. And we are extremely happy that she was able to give us some of her time today and discuss the topics that we're going to share with you. Without taking any more time from our speakers, I would like to turn now to Christina. And Christina, if you can just guide us through the first question that we're going to address today, please. I think you're on mute.
Okay, sorry for that. Well, first of all, I also would like to thank you all for agreeing to take part in this discussion tonight or today. We're very happy to be able to do that and learn with you about particularities of the rules in Shanghai Arbitration Commission. Well, I will start our discussion asking, please, to Ming Chao, please tell us what are some unique features of Shanghai Arbitration Commission's arbitration rules that letting parties should bear in mind? How about Chinese arbitration law and regulations? Are there salient differences in arbitration practices that could lead to a clash of legal traditions?
Oh, thank you very much, Christina. And well, it's a real pleasure for me to join this webinar and more importantly, see familiar faces and also making new friends. Well, it's quite interesting for me to share the Shanghai Arbitration Commission's arbitration rules because during my last webinar together with the Vis East, I think I shared ICC rules with the audience when I was working with ICC, but it's now a pleasure for me to start sharing the Chinese arbitral institutions information with our friends. In terms of the Shanghai Arbitration Commission's rules, the current version actually came into force in 2017. It reflects most of the popular features of most international arbitration rules in 2017. However, the development of arbitration in particular based on the changes in international arbitration practices because of the COVID-19 pandemic, a lot of new rules and practices will be introduced to the new version of Shanghai Arbitration Commission arbitration rules, which is scheduled to become effective early in the second semester of 2022. So I would like to share a little bit more the new features of the new version of the rules, which may be all a little bit more helpful. The new rules are expected to be composed of two major parts. One to the domestic cases, while the other is to be applied to international cases. For the rules to be applied to international cases, it will be pretty much the same as the UNCITRAL rules, so that we do not raise the bar for people to attend Shanghai Arbitration Commission, the abbreviation, the shock arbitration cases, because of the unfamiliarity of arbitration rules. So we generally will apply the UNCITRAL rules in international cases with some sort of guidance note for a smooth application of the same in the jurisdiction of China. Because as you probably know, China has a quite unique arbitration law comparing with the model law. And also on top of the rules of conflict of interest, consolidation, etc., which are commonly seen in international arbitration rules and practice, The arbitrability of a series of disputes will be confirmed in the new rules, such as sports disputes, data disputes, and etc. The use of online platform for arbitration will be facilitated as well. For example, in terms of sports arbitration, given the fact that China is modifying its sports law to set up an arbitral institution similar to the CAS on a national level to deal with sports arbitration, which in fact is an pilot system for sports arbitration in China. Shanghai Arbitration Commission is working with some national sports association to set up Shanghai Sports Arbitration Court as China's sports arbitration court of first instance. It will be similar to FIFA's dispute resolution chambers. Although the FIFA dispute resolution chambers is in-house, while the Shanghai Sports Arbitration Court is external and is some sort of a franchise. We consider it quite possible because our presence in this field. Number one, most of the Chinese CAS arbitrators are on the SHAC panel. And number two, as you know, I have been serving as president of Chinese Football Association Arbitration Commission since 2019. And a SHAC arbitrator has been serving as president of the Chinese Basketball Association Arbitration Commission for years too. So the experience of a SHAC personnel in sports field and the trust we have built up is a great asset for us to set up this court. And also for the data disputes, Shanghai has just set up a data exchange because China has such a huge amount of trade and transactions. Data protection and the data trade has become even more important than ever. So Shanghai, as the first city, has set up a national data exchange center, and the Shanghai Arbitration Commission has been invited to set up a data arbitration center under that exchange. We will provide arbitration services based on the new rules. So that's also something we have to look into, not only to arbitrate disputes, but also for the protection of data and privacy, which is probably even more complicated comparing with the traditional trade. And well, the use of online platform, we have also set up a platform for online disputes, including filing, hearing proceedings, and so on and so forth. Transfer of documents, and so on and so forth. So that platform was set up in 2020, early 2020. And as you know, we are currently experiencing the lockdown. So we have managed to make good use of that platform so as to make most of our cases to be dealt with online. Shanghai Arbitration Commission has more than 6,000 cases last year. So that's a big number for us to deal with. We have to make it more efficient and effective, and the online platform will be quite effective for us. Talking about the unique features which could bring some clash of legal tradition, I would like to share an example of an ICC case, which I'm quite familiar with. It's a case relating to competence. That case, that award was rejected to be enforced in China. In that case, the ICC Arbitral Tribunal decided that it has the jurisdiction over the issue. However, the court in China decided that the tribunal didn't have the jurisdiction, and such decisions came in a concurrent way, so that at the end of the day, the court was unable to enforce that award because if it enforces the award, it will be contradictory to its ruling on the jurisdiction. That happened because of the law and the judicial interpretation in China in terms of the jurisdiction over the question of the jurisdiction of tribunal. The the traditional competence, classic competence theory told us that the tribunal has the jurisdiction to rule on its own jurisdiction. However, according to Chinese law, in fact, the arbitral institution and the court will be the one of first instance to decide, well, not really first instance, will be the one to decide whether the tribunal has the jurisdiction. And very interestingly, on the one hand, the judicial interpretation said, if the institution has decided whether the tribunal has jurisdiction, the court cannot make any ruling. But on the other hand, the text in the jurisdiction, in the judicial interpretation, in fact, indicated that before the institution makes such a ruling, the court still has the power to accept a filing against the jurisdiction of the tribunal. That means there are actually two parties. So there will be the possibility that one party submits a challenge of the jurisdiction to the institution, while the other party submits another jurisdiction challenge to the court, and the proceedings will be held concurrently. And only if the institution rule on the jurisdictional matter before the court still has the power to rule on the jurisdiction matter. That could lead to the result that the court, if rule on the jurisdiction first, then the tribunal's jurisdiction will be decided by the court, even if afterwards the institution makes the ruling that the tribunal has the jurisdiction. That will be contradictory. And that actually lead to the result that on the one hand, ICC tribunal decided that it has the jurisdiction over the matter and continued the proceeding towards an award, while the court in China decided otherwise. The tribunal doesn't have the jurisdiction. And that ruling, the effect of that ruling was carried to the final stage of enforcement, which prevented the court from enforcing the award at the end of the day. So that one, the Chinese court rejected to enforce the award based on public policy, because to enforce that award will be contradictory to its previous rulings. But it still brought us the question whether this system should be clarified or even modified, because it's bringing a concurrent proceeding, which we always try to avoid in international practice. So that may be a good example of the unique feature in Chinese arbitration law and practice, which leads to the unexpected clash in legal tradition and practice. Thank you very much.
Thank you very much, Ming Chao, and it was really interesting, this case. I think we could be discussing just this this theme for the rest of the night, because it's really a very important information, and I can imagine the problems that come with that, because it's not so unusual that a tribunal decides about its own jurisdiction, and if every case that has in which this happened will be challenged by courts, by the Chinese courts, when the decision is to be enforced, it's well, I imagine that can be really a problem. But it's also important that parties that people know about that. So very, very interesting. So going now to Shirley, would you like to comment this topic?
I don't think I have much to comment other than what I've seen with clients is initially, if you look back at clients about 5 or so years ago, they were always quite hesitant about choosing Chinese arbitral institutions because, you know, they weren't really familiar with the rules, with the people. But I will say in recent years, we have been much more, our clients have been much more receptive, not 100% yet, but Ming Chao and team are definitely working towards it, to actually accepting Chinese institutions because of the fact of these revisions of the rules and because of the fact that they're bringing in more individuals with international backgrounds. So all I could say is that these changes and developments, and I do have to apologize, we're trying to fill a round of 32. But with these changes and developments and with every push that these Chinese institutions are doing in order to internationalize and be more consistent with international practices helping, and parties are seeing that. I'm not saying the majority are still 100% gung-ho, but I definitely see a thawing of those that used to be completely against Chinese arbitral institutions. But just to be honest, the Chinese parties, from what we've seen, are having a lot more bargaining power these days. But by choosing institutions with established rules or established teams, I think it is helping the communities.
Thank you, Shirley. Cesar, do you have some thoughts?
Yes. Just to pick up on what Shirley just said, we see in Brazil something similar when we are negotiating a contract, and people, the parties that are contracting with Brazilian parties may generally feel that they should arbitrate elsewhere, not in Brazil. And in the past few years, that has changed. In some arbitral institutions in Brazil have been able to establish themselves as reliable enough so that people will think again and see if it really does make sense to go to a different jurisdiction if, for instance, they expect to enforce a possible award in Brazil. And I think that's something that that's probably what parties are thinking right now in regard to China. If let's say for all the reasons Ming Chao was talking about regarding this specific topic of competence, for instance, it's probably much safer for a party that wants to enforce an award in China to arbitrate in China at SHAC or at another reliable and organized institution, rather than arbitrate elsewhere and try to enforce the award later. But one thing that caught my attention, and actually I wanted to ask you, Min Chao and Shirley, it seems interesting for us looking at that from outside, that the Commission is given such a strong role in terms of making that determination about jurisdiction and existence of an arbitration agreement. And I believe that that's also peculiar to the Chinese system because of the of how structured the commissions are in comparison with arbitral institutions created in other countries, which are often unregulated and are not necessarily given that type of relevance in the system. And so, for instance, in the US, it's competence is very different from what exists in other countries, and basically the matter of existence in the enforceability of an arbitration award is left to the courts unless parties expressly agree or clearly agree that it should be left to the arbitrators. And so it's not very different from a system that excludes the arbitral tribunal from making that determination. But that's left to courts, not to the institutions, right? And so it's interesting that institutions have this role in the Chinese system. And I just wanted to make a comment that something that caught my attention also in the rules is that Chinese is the standard language if parties do not agree otherwise, right? And I think it's very that's useful to know, right? But it's also very good to know that they can agree on a different language, and that will be complied with, because that can be an important issue. And we all know it doesn't make much sense to have dual language or bilingual arbitrations. It's a big confusion and lots of additional costs. And so being able to agree on a specific language seems to be something very useful. But thank you so much.
You're still on.
I'm so sorry. Sorry. It's the time. We're already kind of tired at the end of the day. But I said, I think I would just go on with the second question. And it's following. In mainland China, and this is to Sherling first, yes. In mainland China, is it possible to enforce a foreign award against a parent or affiliate company that was not a party to the arbitration in which the award was rendered? Is it easier if the award is domestic or has been rendered in Hong Kong? What if the award was rendered in Latin America?
So I have wonderful commentators that are going to correct me and give me some tips, because Cesar has thrown me what we call a softball in moot courts, because this is something that we're actually currently working on. We can't give you the full answer yet because clearly we're still in the process, but we do have a client that is now trying to enforce an arbitral award, international arbitral award in mainland China against a parent company. Obviously, we received the award in favor of one of the subsidiaries. And what we have seen, because everyone knows around the world, it's extremely difficult to pierce the corporate veil. But what the client was extremely worried about was the fact that we're going into mainland China, which, you know, to Western parties are still kind of unfamiliar territory. But we were able to convince them to do it because it was a substantial award. And we've seen that the hurdles are no more difficult than what you would face in a different jurisdiction that you're used to, for example, the US or in Europe, or even here in Hong Kong. So while I can't say that we're 100% successful, I can say that the client is currently not unhappy with us because they haven't received or faced anything unexpected. Our understanding is that it is a possibility. Similar hurdles to jump through. You have to show certain elements to show there's good reason to pierce the corporate veil, but we haven't seen anything from the Chinese courts that basically says absolutely impossible. Marcel. Now the question as to whether or not it might be easier if the award was based from, or issued from Hong Kong or in Brazil. I think here we're kind of inferring to the mutual arrangement on enforcement of international or enforcement of awards for those that are seated in Hong Kong or those that are seated in China. There is this mutual arrangement between the two jurisdictions, which makes it easier to enforce. But to be honest, again, in recent years, China has shown that it is being much more arbitration friendly. We have a lot more international awards that are now being enforced. I'm going to let Ming Chao or Rajesh kind of go into the details because I'm going to throw the work back on them as to how the process is if a lower court in China decides that it does not want to enforce an international award. Basically, there's a whole process. It goes all the way up to the highest level before the final decision of not enforcing an international award is actually issued. So parties can rest assured that, you know, China isn't just this black hole of if you go in with an international award to enforce, it's just not going to happen, because they actually take a look at it and they review it, and they will take the decision whether or not to do it. A number of international awards have been enforced in recent years. And also China is becoming more and more pro-arbitration. Sorry, you guys can hear all of that. So I'm going to now mute and let my commentators talk.
Thank you, Shirley. Rajesh, please.
This my experience with the Chinese arbitration goes back to 1996 when China adopted the arbitration law, and I was working at that time, and I saw the growth like it happens. And at that time I was in Hong Kong, so very close to China, and seeing the development, and all the experts from China, they were like engaged in Hong Kong. They were learning from Hong Kong system and the other systems. So at that time, and the enforcement part was the one very much discussed and talked about it. And that was a kind of Chinese law. It gives an assurance that yes, enforcement is possible in China and not have to worry about. Only there was a local advantage or local protectionism, which you say it was there. And particularly this in 96 and or early 97, when Supreme Court came up with this idea about this enforcement proceeding, where the higher people's court, if at the time of enforcement, if they find that this award, particularly foreign award, cannot be enforced in China, they have to send the file and their opinion, their reason, all the way up to the Supreme Court. And in the Supreme People's Court, there was a division was made that they will review it and they will go through it and then they will confirm. If they confirm the decision of the lower court that it cannot be enforced, then the decision will be passed accordingly. And if they think that no, it can be enforced, then the case will come back to the enforcing court to decide that. And that was to take away the idea of this local protectionism, which was the much more concern for the foreign parties. So ever since the Supreme Court has done that practice, in a way, we have seen quite a big jump in the so far as the confidence of foreign parties are concerned in enforcement. Of course, the people will complain one way or the other. If their award is enforced, they will say very good system. And the award, and I have seen many big lawyers and other, the moment their award has not been enforced, they have went in the papers, newspaper, and writing about how bad the system is. But again, it is we know that why they are saying about it. But having said that, the system which was established, it is still working very well. So there's no problem as such in that part, I can say. So if the Latin American parties, if they want to enforce their award in China, and if they have a good award, and it can be successful award, and they can be rest assured that it will be enforced unless until it goes against the public policy or any other matter, whatever the New York Convention says. So that's the one thing. We may have a little bit of understanding or differences about the application of public policy, but that we have with every country. So that we cannot, we can't say too much about it. So far as Hong Kong and China is concerned, if a Latin American party does the arbitration in China and award is rendered in Hong Kong, and then you take it to enforcement in mainland China, this award will be treated a kind of a foreign award, but we don't use the word foreign because of Hong Kong and China relationship. But the mutual enforcement agreement which has been signed by China and Hong Kong, this is in letter and spirit. If you look at that, the language, everything is same like New York Convention. So if you are happy with the New York Convention, there's no reason for you not to be happy with the grounds and the procedure and everything for your mutual enforcement. So that will not affect you very much. The situation will be the same. So much so that when CTEC opened the office in Hong Kong, again, there was a question that CTEC in Hong Kong should be treated as a domestic institution or as a part of the mainland CTEC, or it should be separate. Again, the clarification came and it made it very clear. The CTEC Hong Kong is different from CTEC China. So when you are doing CTEC, using CTEC Hong Kong to resolve your dispute, then it will be treated as a Hong Kong award, and you have to take the route of mutual enforcement. So that's there. More so, like between Hong Kong and mainland, if the parties are choosing any position and they have an interim order to enforce, now there's a new arrangement between Hong Kong and China, which is very useful. You will not find in many countries to have that if you want to enforce the interim orders and all. So that's very, very unique and very important if you are thinking about doing the business in that sense. Coming back to the question of enforcement against the parent company, this is not only the problem, but the China, it is problem with everywhere. Because even in the corporate law principle, it doesn't give you any reason to pierce the corporate veil for the purpose of simply enforcing the award. Because enforcement of award is basically like we are recovering the money. And that is not a good reason. We know that from the corporate law principle that there has to be some kind of a fraud, which you have to, or some illegality, which can give rise to the piercing corporate veil. But then why as an enforcement court will get that power to pierce the corporate veil? That will be very less likely because the New York Convention doesn't give that opening. So even if the court is exercising that or wants to exercise that power, sitting as an enforcement court, applying the New York principle, it will be very hard. And actually almost like uphill task, and I will say almost close to impossible to do that. So then how as a lawyer or as a consultant, we can advise the party to use that process and go after the parent company or affiliates. One simple formula or one easy way to do it, instead of suing them as a party, we can also sue them not as a parent company, but we can say that if parent company and affiliates have any transaction going on between the losing party in the enforcement, then there's a money which has to be transferred or some kind of a benefit which can be transferred. And that money we can recover as a part of New York Convention in that one. And this has happened, not with the Latin American company, but if you remember Jica Mine case, which was a Democratic Republic of Congo. And the Jica Mine had a case, and after a very long time, English Privy Council gave the decision. And in that one, they said very clearly that when you are coming for enforcement, just because a company is connected with another company, and in that case, it was a state-owned enterprises. This is just because you are part of the estate and you are a state-owned enterprise, that doesn't mean the estate is debtor in that case. It is entirely for the parties. And over there, very interesting, the UK Common or Privy Council has agreed that the corporate legal personality of the companies are very important, and say that Jica Mine established on its own. So a state-owned enterprises has its own corporate personality, and a state is not connected, even if it is a state-owned enterprise. So they separated very nicely in that case. So if we go back, the piercing of corporate veil, which has origin in common law, and if you go back and look at the Privy Council decision, you will find that they are following the same. So that has not changed. It means they have not used the enforcement mechanism to pierce the corporate veil. I think it will be legally, it will be very impossible. So these are my a kind of a long, short comment on these three topics on that one.
Yes, well, you brought some very important insight. Is that before being a arbitration matter, it's a corporate law matter. Yes. So, Cesar.
Yeah,
do you have some thoughts on this? Yes.
Yeah, just some quick comments. I thought it was very interesting when we were preparing for this that I saw a paper of 2020 that dealt with I don't know if that's exactly a judicial interpretation, but it's something that's called a notice from the Supreme People's Court on the topic of disregard of the corporate veil. And as Rajesh had mentioned, they interpret Article 20 of the company law of China, and basically lay out what the grounds and what the effects are for various types of disregard of corporate veil. And as Sheridan mentioned, they are very similar to the international practice in that area, right? The main point is really what do you do with an award that is rendered against a subsidiary when you have to go after the parent company, or when the subsidiary basically disappeared. It's a shell, an empty shell, all right, after doing business in a certain country, and then it disappears, and you're left there with an award that's basically meaningless if you can't go after anybody else. So of course, these principles that are laid out by the Supreme People's Court are based on the idea of fraud and all that. But I think I would be a little more optimistic than Rajesh about trying to enforce this, because I think we can maybe break this into two parts and see that it's possible to recognize an award or recognize the award rendered against the subsidiary, and then enforce it against another company, the parent or an affiliate, based on these fraud principles that allow disregard of corporate veil. And that is relatively, well, I wouldn't say it's common, but it's not unknown in domestic arbitration in Brazil. There are quite a few cases in which an award at the enforcement stage was enforced against another company based on a special procedure that exists under Brazilian civil procedure for disregard of corporate veil. And I would imagine that that's possible. You would be able to recognize an award, then at the enforcement stage, take that additional step. And my impression from Brazil is that it would be easier to do that with a domestic award rather than an award that has to be recognized under the New York Convention, because of everything that Rajesh said. And so and that would be maybe a reason for a foreign party to arbitrate in China and or Hong Kong, and have a domestic award, so to speak, to enforce against a Chinese party if they have to enforce it against a parent company. But then, well, that's basically what I had to comment. And I see that Ming Chao has his hand raised.
Yes, if I may, I fully agree with Rajesh and Cesar that the practice of veiled corporate principle is pretty much similar to the practice internationally. And in fact, I have to assure that many of the Chinese judges are actually very well trained overseas. For example, Hong Kong universities are in close collaboration with Chinese courts to train Chinese judges via the LLM programs and PhD programs. And also take myself as an example. One of the Supreme People's Court judge who is actually responsible for the enforcement of international arbitral awards studied together with me 20 years ago in Manchester. So the Chinese courts actually started to train their judges, as you can see, 20 years ago. And so many judges are very, very well trained overseas. They know the practice internationally. And in fact, they are in the position to be arbitration friendly because they are trained to be arbitration friendly. So take Shark as an example. in 2021, we had no arbitration awards set aside in China, all those 6,000 cases. And only one award was not enforced because in China, set aside and enforcement, there are actually two different systems. So the award was not set aside, but was not enforced in a province, a quite remote province in China, where I think the judge didn't have overseas experience. Then as Shelly and Rajesh mentioned, there was a internal reporting system for the judge to report this potential decision to the higher court. And eventually that ruling was overturned, meaning Shark didn't even have any case unenforced in China out of that 6,000 cases. So that's a quite good record, I would say, and a very pro-arbitration attitude. However, to be fair, I would say it would not be professional if courts do not really supervise arbitration at all. I mean, if there are some courts which have never turned on the application for enforcement or never set aside any awards, that would be problematic, I would say, because where there is a good award, you should enforce it. But if that award is not good, you need to think twice. For example, recently, the Hong Kong court rejected to enforce a Chinese award because the judge said it would be against natural justice if that award was enforced. I mean, there was no procedural problem actually. And we all know that the award was not made based on fundamental natural justice. There was something cheating in the case. So the Hong Kong judge decided not to enforce it based on public policy. That's quite fair. And also my own experience when last year, I was consulted by the Supreme People's Court whether a FIFA decision shall be enforced as arbitration award based on New York Convention. And my consultation opinion to the Supreme People's Court was no. As friendly as I am, as pro-arbitration as I am, because the FIFA decision, in fact, is not an award, number one. And number two, that award was a disciplinary award. And that's not commercial award. That does not fall into the category of New York Convention, according to the Chinese agreement to the New York Convention. And also, the court has to consider the wide effect that enforcement could bring to the whole system. If we enforced the FIFA award, then should we enforce any other decisions of any other sports associations? FIFA has a very, very good judicial system, but what about the other sports association? Many of them actually are very corrupted. And many of them, in fact, had their CEOs investigated by CIA and FBI. How can we trust them? But if we enforce the FIFA decisions, should we actually apply the same principle to enforce all the decisions of all the sports associations? That could be a huge problem to China. So my opinion to them was not to enforce that decision. So all in all, as long as it's a good award, it will be enforced. But the court is still in the position and has the mandate to supervise it. Thank you.
Yeah, I was just going to comment on that idea of how important it is for courts, that there are courts to supervise awards. And some time ago, the Portuguese Supreme Court issued a decision that was related to Article 3 of the New York Convention, and that was basically the idea that since a foreign award cannot be treated in a more it cannot be subjected to higher requirements or stronger requirements than a domestic award, then recognition should not take place because, of course, domestic awards do not have to be recognized. And so, you may know José Miguel Judici, who is a very prominent Portuguese arbitrator. He wrote an article criticizing that decision and saying how important, how crucial it is that courts do exercise their power to supervise awards, and how important that is to the system, because you can't really have legitimacy in an arbitration system that is basically outside any type of control. So that was just what I was going to say, to agree completely with Ming Chao. Should I, maybe I should move on, Christina, to question 3?
Yes, please.
Okay, so yeah, I'll do that. So this is to Rajesh. Rajesh, when arbitrating in China, in your opinion, does it make a difference to use a domestic institution such as SHAC, or to use an international institution like the ICC? And it's easy to discuss this with Ming Chao here, because he was at ICC and now he's in SHAC, so he can comment on both of them. So Rajesh, what do you think?
Exactly, I was going to say the same things, Cesar, because our friend Ming Chao was in ICC, so we supported that ICC, and now he is in SAC, so we are also happy with SAC. So from our side, there's no problem with that because he's there. So that's another thing. But jokes apart, there's another. If I have to advise any client, and I do quite a lot, because many Indian clients, they always think that going to China is like, they think that, oh my God, I cannot go there. But the reverse is that if you, at least in China, you have a system and established arbitration practice. When my Chinese friends ask that, should we go to India and select the seat of arbitration, which center to select, which institution to select, I can't even pinpoint, and I can't even say that, okay, this is the Indian center where you should go. So CTEC had long history, at least we can point and say that go to CTEC. For India, if you ask me, I don't even have a center to tell you. So this is the difference. You can see how it has happened and what the difference is. So far as selecting institution is concerned, for your dispute, and if you are a foreign party, whether you select a domestic institution or ICC or any foreign institution, a foreign arbitral institution in China, I would say that it will not make any difference, because any institution who are in China, they are there and they are all acting in the same. Only the rules are different. But I'm sure you know now that earlier CTEC had the monopoly on the foreign award of foreign arbitration, and the foreign element is still continuing in Chinese system, where if a party is a foreign, then it will be considered as a foreign award and the foreign international arbitration. So that party is still there. The changes which has happened is that CTEC has no monopoly, and that monopoly, again, it was broken in sometimes in 98. Beijing Lido case has already broken that monopoly. And therefore, then since then, CTEC has become an institution where you can do your domestic arbitration, and you can also do the foreign related arbitration. Same like SAC, you can also do the foreign related and domestic, and Beijing Center also can do that. So basically what has happened now in China, all the institutions have become a center which can handle both domestic and a foreign award. So there's no difference. It's only because of the foreign element, category will be different, and therefore the next step of enforcement will be different. That's the only difference will come. But again, the principle will be the same, to my understanding, and I have not seen any different treatment. So far as the ICC or any foreign institutions are concerned over there, and if they are rendering over there, again, they will be treated as same like any other domestic institutions over there, depending on whether they have a foreign cases or not. The only one thing is that ICC cannot take the domestic cases. Now, Cesar, you were saying a very good point. following the tradition from Brazil and Portugal and other for this enforcement part, recognition and enforcement, dividing the two parts in that one. Very, very interesting and very conceptually, it is correct. And this, whether you are doing with the same party or different party, the first step is recognition in any way. So the award has to be recognized first before it goes to the enforcement. So it's a conceptual approach in that sense, if you think about that. So yes, even if you have you want to use the domestic arbitration to get advantage of enforcing against the parent company and affiliate, even if it is a domestic award, still the situation will be the same, that who is the party to the arbitration award. And even if you recognize, still you need to find the link that why the third party has to pay the money if you go for enforcement, unless until you have the monetary connection or some kind of a connection. So it will happen. I know why the Portuguese author have written, and recently in last 2 years, you will see many people from Israel, Portuguese, and other civil law tradition, they have written quite a lot on the recognition part. And the trigger point was in Ancestral, because when the Singapore Convention was discussed, at that time also the recognition of the mediation settlement was discussed. And again, people, all those people, they went back to 1958. And they said that in 1958 also we noted our reservation about this idea of recognition. And therefore they're saying that in Singapore Convention also they will not recognize the mediation settlement, because again, why the court should start acting or doing the machinery should start working towards this if there's an award or the party settlement which is not recognized. And this concept of recognition, particularly in Israel, has a big problem. And still they are struggling with that, and they cannot get around that. Russia has another problem. So that's why. So all this discussion has very recently come, and that's how it has started tying up. So what was the solution? Solution was that we have to understand this, the functional approach of recognition. What is the function of recognition? Function of recognition, that somebody who has decided, three private people sitting as a tribunal, they have made a decision. We take this arbitration award as a decision as decided by these three parties. The traditional view is that only judge can decide the party and the three individuals cannot. But now it is established principle that in arbitration, those three people are making a decision. So that's how the recognition has become easier. So that part is clear in that one. Whether that will solve, I don't know. We have to see the interaction with this practice. And thank you for organizing this Latin America and China this discussion, because it's so far away. Nobody has discussed. I only almost like 5-7 years ago, I attended a program in Shanghai where the Latin American Center was established and the discussion was there. And after that, no discussion happened. So with this interaction, we can learn from each other and say that can we use this technique? I'm not saying that it cannot happen. It can happen. But my short answer again, for the picking of the institution, it will not make a difference. And if you are picking the institution because of the rules, almost all institutions have very good rules. There's no problem in that. If you are picking the institution because of the arbitrator, and think about it, Cesar, you are yourself on the SAC panel. If anybody chooses you, how does it make any difference? Because you will be delivering the award, whether you are as an ICC panel or you are SAC panel or you are any other panel. You individual, you are qualified and you are talented and you will do the same thing. Doesn't matter which rule you are applying and which place you are going. So if you look at the list of arbitrator of all Chinese domestic centers also, they are pretty international. And all who's and who's are there. And thank you to Siak and Ming Chao to going so broad in the world, to rope in so many talents from around the world to put in this panel is really incredible task. So with those kind of things, I don't see that as a matter of process, as a principle, as a rule, as a talent, as a caliber, there'll be any difference from my view.
Thank you. Shirlene, would you like to make any comments?
The only thing I would say, or the only things that I would say, in essence, I agree with Rajesh. But for me, when I do speak with clients about choosing an arbitral institution, it is quite important to them. Again, for basically perception reasons, right? everyone's going to say, oh, the ICC, it's safe. You know, everyone knows how to do the ICC, et cetera, et cetera. But what's been great about the domestic institutions, the people in the domestic institutions understand how things are going on within the jurisdiction. So for example, when we promote Shanghai, and now we've got Ming Chao, and also Ming Chao's brought a brilliant team to the SHAC. And we're able to tell our clients, look, they're international. They came from an international institution such as the SIAC, the SIMC, Singapore, Hong Kong, China, all over. They brought that knowledge now to the SHAC. And not only that, they've brought, sorry, it's really loud. Can you guys, sorry. So they've brought that knowledge from not only the international institutions, but they've also now have the knowledge of the domestic jurisdiction. Because generally speaking, while SHAC is known, it will have more and more international cases, there's going to be some connection to China. And therefore, you're going to want a secretariat or management of the institution that is aware of the local customs and the local laws. And that is what I think personally you would get more with a domestic institution versus something such as the ICC. ICC is great, but let's be real, their team in China is 3 now, and the 3 are, they're not case management, right? Because only limited institutions can actually administer arbitrations within China. So that's what we've been promoting to our clients. Again, it's less of a tough sell than it was before. It's still an upward slope, but we're getting there. And Ming Chao is definitely, with all of the changes, we're getting there slowly. And I believe in the next 5 years or so, we will see more and more.
Yeah, from what we were discussing before, I would imagine that one aspect that parties will take into consideration when selecting an institution is the fact that it does have a role under Chinese arbitration law that's very peculiar, right? And this role of making a final determination regarding existence of the arbitration agreement. And so, of course, institutions always have an important role when picking a chair when parties are not able to do that, or sometimes appointing all 3 arbitrators when there are multi parties and they cannot agree among themselves. And so, but of course, that specific role of arbitral institutions may be peculiar to China and maybe something that parties will take into consideration. And I would just like to open the floor before we move to the other question. If I don't know, Ming Chao or Christina, if you want to make any comments. If not,
Christina
we'll
first, please.
No.
No.
Right.
No.
No. Okay. Okay. Yeah. Well, if I may, replying to Cesar's question in terms of the role of institutions in arbitration. You know, the biggest problem is that China is always having a huge number of cases. Shanghai Arbitration Commission has 6,000 cases per year. If it is for the court, the Shanghai local court, to decide whether the tribunal has the jurisdiction, it would be crazy. And in fact, to share with you another development, Pudong, is a special district of Shanghai, which was the policy of opening up that China had to deliver it very well. And recently, Pudong has been granted the power to legislate by the National People's Congress to legislate a regional arbitration rules audience, and we are actually working together with the local People's Congress on that legislation. In Pudong, we can expect from later 2022 or early 2023, ad hoc arbitration will be allowed. However, when we proposed that to the People's Congress, the judiciary system were extremely against it, because at the very beginning, we in the text said that the courts should in the position to appoint ad hoc arbitrators if the parties do not agree on the denomination, which I think many, well, in fact, that's unsexual law. But the local court was mad about it because, you know, each judge actually has more than 500 cases every year. Some of them even judge them more than 800 cases a year. It would be totally impossible for them to do this kind of a nomination. So the compromise at the end of the day was for SHAC to be the appointing authority in ad hoc arbitration if the ad hoc arbitration is seated in Pudong. So that's actually the similar reason why the determination of the jurisdiction challenge is the power is given to the institution instead of entirely given to the court. Returning to the question of SHAC and ICC, you know, I love both of them. I love ICC very, very much. And for SHAC, I started enter into the arbitration arena in 2003 with SHAC. Then I continued to be a law professor, then working with ICC for almost 6 years and returning to SHAC. I think there are a lot of similarities, but choosing ICC or SHAC, they all have pros and cons. ICC is great at dealing with complicated cases, while SHAC is probably better at dealing with smaller cases because it has thousands of cases experiences every year. So efficiency actually is the life of SHAC. ICC actually has some around 20 to 30 counsels and deputy counsels around the world, dealing with 1,000 cases a year. SHAC now has around 40 counsels and deputy counsels, dealing with 6,000 cases a year. So the counsels at SHAC have to be very efficient, and the arbitration rules of SHAC have to be very efficient. But in terms of the trust of local courts around the world, which may not have extremely good international exposure, ICC is apparently the better choice because everyone knows ICC. So if one day the award, we expect it to be enforced in some country outside of China, in particular in the courts which are relatively unknown to all of us, are relatively remote, I still would recommend ICC because it is widely trusted. It has the great tradition, and people have faith in ICC. We have to be very honest. While for SHAC, it is still trying to elevate it into the international arena. We are very proud that a lot of colleagues have joined us. As Charlene knows, Winnie Huang, who worked with Singapore International Mediation Center, Dixin Deng, who used to be Michael Huang's assistant at the IFC court, Ryan Guo, who used to be assistant of Charles Brower, the ICJ judge and the US federal judge. And also there are 3 ICC Advanced Arbitration Academy participants join us to be Deputy Secretary General, Deputy Secretary General of Court of Construction Arbitration, and a special advisor to the board. So I'm sure that SHAC is trying to improve its quality as well as its international standards. It takes time, but I trust that it applies to all the local arbitral institutions. The more competition, healthy competition, the better the environment will be, and the more choice clients will have. That's a good thing. Thank you.
Thank you. And Christina, can you, would you introduce question 4, or can I go ahead?
Yes, I will introduce it because this one is for you. Is Shanghai ready to absorb cases from foreign parties? To what extent is arbitrating in China interesting for Latin American parties?
Okay, thank you. As Rajesh was saying, it's well, it's very important that we have this opportunity to talk between some Latin American lawyers and Asian lawyers and exchange these ideas, because when we do that, we come to the conclusion that systems are much more similar than what people would expect, and that some of these perceptions about places to choose and places to avoid are probably misconceptions about the reality of those places. And I especially, I think the Brazilian system is much more similar to the Chinese system than one would expect. For instance, we have, in theory, we have ad hoc arbitration, which is something that is not accepted in China. But in practice, we don't. Of course, we can have ad hoc arbitration, and they exist, but our arbitral institutions have a very strong role as well in Brazil in the practice of arbitration, even though they don't have such a strong role as Chinese institutions have under the law specifically. Brazil has about 1/3 of the international arbitrations in Latin America. It has about 20% of the domestic arbitrations, because Peru has a huge number of domestic arbitrations because of a very specific feature of Peruvian law. All government contracts in Peru must be subject to arbitration. And so that means they have like 10,000 cases every year, because, well, that's an exaggeration. They have about 2,500 cases every year. But most of them are government related because of that feature. So we can say that Brazil is, let's say, a representative country in Latin America to understand how this system works, and we see that arbitral institutions, since we changed our arbitration law in 1996, and arbitration really happened. It really became something that of actual practice in Brazil. Well, we see that all that was much or very much related to the activities of arbitral institutions. Those institutions were the ones that promoted arbitration, that persuaded parties that arbitration was a reliable system, and that made basically arbitration grow in Brazil. Now, as you may know, Brazil has an arbitral institution, CCBC, which was is one of the big supporters of the Vismut, and their rules were chosen for 2017, if I'm not mistaken, and so and they are, as I said in the beginning, they are now seen by international parties as a reliable institution, and São Paulo is seen as a reliable seat for arbitration. But when we look the other way, we may have in Brazil, like the whole country and the whole year, we may have maybe 1,500 arbitration cases every year. And so when we look at Shaq's numbers, we can only see how reliable and how trustworthy an institution that is able to handle 6,000 cases a year can be, right? And when we look at the list of arbitrators, I have as a disclaimer here, Christina, I think all of us here, right? Christina, Rajesh, Shirlene, and I are on the list, and so I'm not saying that because we are on the list, but there are 110 nationalities represented on the list. Only in if you take Latin America only, there are I think 6 different countries in the most important arbitration jurisdictions like Brazil, Chile, Colombia, Mexico, Argentina. They're all represented on the list. And so for a Latin American party, if you have to choose, if you have to appoint an arbitrator, and if you are more comfortable with a Latin American arbitrator, you will find a Latin American arbitrator on the list. In fact, of course, those statistics can be interesting when you look at them. But in fact, out of the 75, or I think it's 75 or 70 foreign-related cases that Shaq handled in 2021, 15 were from Latin America. So that means 20% of the foreign-related caseloads of Shaq is Latin American. I don't think there is any reason why a Latin American party would be or should be hesitant to arbitrate in China, specifically in Shanghai, and given this history of Shaq in all those numbers, and we saw from our previous discussions many advantages of arbitrating in China or in Hong Kong if you need to enforce an award against a Chinese party, and so I think that it should be something more and more common for parties between two very economically active areas of the world, right? Brazil and China have a huge mutual line of trade, and so it should be something more and more common to consider arbitrating in China as an option in those contracts. And well, so I think that's those are my initial comments, at least, Christina. And if I think we can open the floor. Thank you.
Yes, I would like to hear Ming Chao on this topic also, but I would like to know from this 6,000 proceedings during 1 year, do you have, where is Ming Chao? We lost him. So I was going to ask him whether he has the number of how many of these cases are related to Latin American companies, but
I have that information here.
Oh, you have this information?
Yes. I just need to find it. Sorry.
Okay. So while we are recapturing him, Rajesh, would you like to comment on that?
cases, I think Cesar already mentioned, I think it was 45 or something, or 55.
Yes, but not
Yeah.
about the cases, about to what extent is arbitrating in China interesting for Latin American parties?
Now the one party said that it will become interesting for the Latin American party if they know that the Latin America and China has some kind of a relationship, commercial relationship or trade relationship going on. And if you think about it, most of the commercial arbitrators and other, we don't look at little one step ahead or one step above. My suggestion is that if you think about that, China's relationship with Latin American country, how many countries have a FTA or free trade agreements or regional trade agreements signed with China? Because that agreement, although it is between the two governments, it gives the reduced tariff and all, which encourages the businessman to start business in the country. So if you look at China, China has so far first agreement they signed with Peru, Chile, Brazil came later, Ecuador, Mexico, Venezuela, only 3-4 countries. These 4 countries, of course, they are big in Latin America, but still, if you look at the trade between these two countries, China and the whole Latin America, these 4-5 countries, and the agreement was signed from 2001 onward, not very far, because China became WTO member, then they signed. And then the trading has started, of course, under that umbrella. In that one, for so many years, we only have a trade of 700 billion. 700 billion for the country like China and the whole Latin America is nothing. It's just a peanut. So if the commercial exchange is getting very less, then of course, if there's no commercial relationship, then we cannot expect to have a dispute, and then we don't have to go. I'm not saying that we have to encourage dispute. We don't have to, we are not saying that. But what I'm suggesting, that people like who are the leaders in this field, like you and Cesar in Latin America and many other colleagues from different countries, the Bing Chao, Serlin, and all in China, in that one, we have to get engaged in this kind of a discussion when the government to government are having this discussion. All these FTAs which has been signed, it goes for the review process. Every 2 years, there's a discussion is given that the two parties talk. You need to propose that idea that we should encourage the commercial party to do that. Earlier, it was not a trend, but after TPP and CTPP, it is a provision was added that the governments will encourage the local parties or local businessmen or their own countrymen to use arbitration as a dispute settlement mechanism. So assuming if China and Brazil in their review, they come up with this and they encourage the parties to do that, if it is this statement coming from the government level, it will make both parties or the businessmen very happy, and then they will start accepting. If we go as a lawyer and the client's lawyer and tell them that go to China, go to Brazil, that will not sell very well. But if it comes from that kind of a level, institutional level, then it's very good. Then you look at the Brazil's particular engagement. Brazil has a very special place because they are also member of BRICS, and China is there, Brazil is there. So you have a direct relationship, even if you want to talk about two countries. You still have an opportunity, and every 2 years there's a meeting. Every year, basically, we have a meeting on that one. So it can be lobbied there. Third, if you look at that Belt and Road, China is very interested in Belt and Road. How many Latin American countries have joined? Very few. Only Argentina, Brazil, and some other country. Very few countries are member of that. So it's not a good trend. So we need to lobby on that. And the recent lobby, which we have seen, that many Latin American countries joining the international, this community and the cooperation, was the Singapore Convention. And if you look at out of 55 countries now, I'm happy to tell you that now we have 8 Latin American countries which have signed this agreement. So what will happen overall, if you look at arbitration as such, you have to look at an ADR perspective. In this ADR perspective, what will happen? If your client is going for mediation with the Chinese party, even this mediation settlement can be enforced in all these signatory countries. So we have one option. If mediation doesn't work, then we have an arbitration, and then we can encourage. So you have to use your position of in your leadership in your country to really get open this one. The more trade will happen, the more discussion will happen, the more trust will build, and then we start using it. Nothing more than that. And these are the things I was trying to suggest that we should do that. And this opportunity to interact with the Latin American lawyers talking about system in China and Brazil is a very good start, and we should continue like that.
Oh, yes, for sure. Yes, this is very important, the exchange of ideas. And it's, well, for us, I mean, the common view is that China is still a big mystery for many commercial partners here, but you can feel, you can sense that things are changing. And I mean, the position that Chuck is assuming and is like a leader in opening and calling and including in the arbitrators list so many foreign arbitrators, and it's really helpful for the companies to decide to choose arbitration in China. So Ming Chao, do you have some comments on this?
Yes, thank you very much, Christina. I shared the views of my colleagues. Yes, it's time for people to work together, and in particular during this very critical moment. That number one, the pandemic has divided people into different continents. They cannot, get together, social, drink wines as we did years ago. That has been a big problem for the social connectivity of the whole world, and also the war has been there. It's again another challenge to the whole world. So, when I worked with ICC, I still remember the old saying that we say in ICC, where there are businessmen, there will not be soldiers. And that's the idea of a merchant of peace. And for us, arbitral institutions, not only SHOC, but also our Latin American colleagues, Brazilian arbitral institutions, we are all trying to help resolve the disputes amicably, friendly, and efficiently, so that business can continue. That's very important. And we are not only providing dispute resolution services, we are actually a part of the entire business environment, which will be very important to the international business community. For Shanghai Arbitration Commission, I think it's again the very first step. It is a great honor for us to have all of you on the panel. I have to confess that we do not have so many cases at this moment, because we only have tens of cases from overseas, and only 15 from Latin America. But on the one hand, I'm sure that our Chinese clients are very much keen to know our Latin American arbitrators, because the Chinese businessmen have been investing in Latin America very much. And to be very honest, I'm sure that they do not only want to know arbitrators who can arbitrate their cases, but also legal professionals who can help them to avoid arbitration. So that's a pool of arbitration is not arbitration, but for a business environment. I hope that will help the continuity and stability of business relationships bilaterally and unilaterally. As Rajesh said, we should lobby that, and we should to make efforts to make that happen. Thank you.
Yeah, and actually, we're moving into our final question here that has very much to do with that, with the idea of resolving disputes or avoiding disputes instead of having to arbitrate them. And but just before we do that, we have a question here from the audience. and I'm going to read that to you, and I'll just open to the floor, and whoever wants to reply. This came from a Brazilian lawyer, Tel Silveira de Oliveira, and I will read the question here. As we all know, since the beginning of President Xi Jinping's government, China has made a great effort to strengthen the rule of law. We recently had the enactment of the Civil Code, for example. Do you believe that this legal legislative development with the establishment of more solid laws can further facilitate the acceptance of China as the host country for arbitration and attract more and more international attention? Would anybody like to comment?
Well,
yeah, Minchao, please.
Yes, perhaps I can say a little few words for my colleagues to comment. It is true that President Xi has tried to bring in more solid legal systems, including the modification, for example, arbitration law, sports law, and so on and so forth. And this, in fact, reflects the natural trend of the development of a government and the country, that when the economy and the country is stable, they will have to institutionalize all the legislations and modernize such legislations so that the stability can be sustained, can be sustainable. So it is, and also as a side effect, side result, the more stable the country is, the more possibility for business to come into this country, to this area. So personally, I think from a business perspective, the better legal environment China has, the more possibility business will come, and the more possibility, the more attention it will attract from the business and the legal community, so as in the arbitration community. However, given the fact that China, interestingly, China is usually not considered a neutral seat, because at least one of the parties will be from China. So I personally do not see it very easy for China to become a popular seat of arbitration. But instead, there will be, I trust, more and more arbitration lawyers and arbitrators to play increasingly more important role in the arbitration community. That's it. Thank you.
Yeah, I think that's another similarity with Brazil. We would like to be a hub for international arbitration, but we are above all a place that we consider very safe for the cases that involve at least one Brazilian party. And so what we are telling the world is that international parties that have business with Brazilian parties can rely on Brazil as a seat. Same thing with China. I would say that it's probably business related to China that will end up being subject to arbitration in China, as it is in Brazil. But so thank you, Minchao, and I would like to ask Christina, please, if you could address some of the issues related to mediation and conciliation, to other forms of dispute resolution. And so how do tribunals manage mediation and conciliation efforts during the case? Are they incentivized to make party, meaning under Chinese practice, under the Shak rules? Are they incentivized to make parties reach an agreement? Are there any consequences for using these methods, such as mediation and conciliation, during the proceedings?
Well, Cesar, as I understood from my readings preparing for this webinar, is that it's within the Chinese culture to seek for mediation or conciliation services for all kind of disputes. And following this, the ruling of the Chinese Arbitration Act, SHAC rules have an express chapter about conciliation. It's called conciliation or also intermediation, because it's really an intermediation that the arbitral tribunal may exercise during the proceeding. Well, it's based on the autonomy of the parties. Parties have to agree, expressly agree with it. It's a very flexible possibility. It's before hearings, during the hearing, after the hearing. And it's very, I think it's very interesting because contrary to our arbitration culture in Brazil, it's within the arbitral tribunal to really exercise this power, as I understood here. So, and it's always a challenge for the arbitrator to assume this role of conciliator, of intermediator, because it's always the risk that this active role that he or she is performing may give the appearance of bias, or behavior can lead to a challenge of its impartiality at some point. So in our proceedings in Brazil, usually when there is a conciliation going on, the proceeding is suspended, and parties use a third party, which can be also used in SHAC proceedings. But as I understood, the tribunal may assume this active role. And but there are also some ruling that tries to prevent some questioning about that, is that the proceedings shall not be recorded. The statement, opinion, view, or proposal stated by either party or by the arbitrators in the process of conciliation shall not be invoked in a later proceeding. And important, the arbitral tribunal shall not take the opinions stated by either party in the conciliation proceeding as grounds to render an award. But we know that is something difficult to separate, yes, because once it enters in the decision-making process of a person, it's difficult to separate it later. So I would really like to know from you all how it really happens in practice, if the tribunal really assumes this role, or the usual way of handling it is to call a third party to help with the process.
Thank you, Christina. And I think, well, Ming Chao, if you could comment on that point, and maybe Rajesh and Sherlyn, if you want to comment afterwards.
Yes, a little bit. Well, personally, I fully agree with Christina, because we are very much trained in the international arbitration arena, and it appears to me that as Christina correctly pointed out, that arbitrators can very difficultly serve as a mediation and become a neutral as he should. This practice actually is rooted in the Chinese litigation practice, because the civil procedural law in China allows the intervention of judges as a mediation wearing two hats at the same time, even though it is also required that the judge should remain neutral when he delivers the judgment. The reason why I think was, China has the civil procedural code for only like 30 years, which after the Cultural Revolution. And right after the Cultural Revolution, there was a very limited number of judges who, number one, the number is very limited, number one, and number two, who were not well trained in law, but they are usually older men who knows the culture and how to deal with the problems. So during that period of time, it was very difficult for the Chinese judicial system to provide another set of list of mediators to serve as a third party to jump in to mediate during the litigation. They have to ask the judge to wear two hats at the same time. And also for those judges who are not very well trained in law, they at least know the culture and that they can tell who is right and who is wrong, and that they mediate so that based on the basic understanding who is right and who is wrong, so that the case can be settled instead of judged purely based on law. And also I have to confess, 30 years ago, China didn't even have a lot of law, a lot of legislation after the Cultural Revolution. So that was the tradition and history. And this kind of a practice was put into the legislation and continued up to now. But in the next version of Shanghai Arbitration Commission arbitration rules, mediation will be separated from arbitration rules, and it will become similar to the ICC practice, meaning arbitration, and if a mediation is necessary, a third party will jump in to mediate, so that the neutrality of arbitrators will be ensured. Thank you.
Thank you. Before we close, Rajesh and Sherlyn, would you like to make any comments?
Just a short comment, because on this topic we had lots of discussion, and I had a privilege of having in several sessions and several discussions with the main proponent of this concept of mixing arbitration and mediation, particularly Professor Tang Haozi. He's no more now, but in Chinese circle and all, like we consider him as the leader in this field. And he was the one who was speaking in Arbitral all the time that we should consider this aspect. And he talked everywhere. For all these answers, the bias, violation of principle of natural justice and other, he gave a very, very nice solution on that one. He said that even with the arbitrator acting as a mediator, it will not happen if parties have not given consent. So the parties' consents are there. So this is the fundamental basic requirement for ADR process, which he says that we get it. Then the question of bias, yes, as a human being, we are there. But he posed a very nice rhetoric question to them, to everyone. He said that even if when you are acting as a mediator, you find a party is tricky and he is not solving and you think that he has done or she has done wrong, now you become an arbitrator. Can you write an award? And in that award, can you write it that during mediation, I observed this and therefore I'm going to decide like this? You cannot, because in arbitration award, your reasons must be given, and the reasons must be based on facts and law and evidence. So how can you ignore those? So even if you are a little bit biased, you have some views and all those things, even as an arbitrator, we see the witness and we have our hunch that whether this witness is credible or not, but can we do anything? No, we have to go by the reason. So he said that reasons are given in the award, otherwise how you can go enforce? People can challenge you. So on the reason we have to have those things. So there's no problem. Then the natural justice concept came on the, and his suggestion was that instead of one arbitrator in the panel of three, all three arbitrators should act together and the chairman should never be the mediator. So in that way, the three arbitrators are listening to what is happening. And they are the one who are going to make a decision. And out of these three, two will be the party appointed. So Everything is covered. So his concept were like that the idea of the bias and the natural justice can be cured. There's no problem in that one. And he was very strong supporter of that. And I feel that. And that's why in Hong Kong, we started this combination of arbitration and mediation moot. Exactly the same thing to demonstrate to everyone that it can work. It can work. And we had a last session, we had a demo of all that, how it works in Chinese system. So we gave everything. So you can see those things is there. But interesting part is that if you look at the mediation and in Australian law, because Professor Lawrence Street was also against that. But if you continue that, even in Australia, you will be very surprised that Western Australia, New South Wales, Queensland, Victoria, they have all changed their mediation law. And in that one, they have added in arbitration law, they say that an arbitrator can act as a mediator in the same case. They say that. And with the party's consent, there's no problem. They have also said that the mediator who has mediated the case and mediation failed, then even with the party's consent, that mediator can act as an arbitrator. No problem. Again, the party's consensus is there in that case. But why we have to worry about this mixing? If mixing is a problem for you, now you don't have to worry about it. We have a Singapore Convention. And as Ming Chao said, that risk management, if you do that, you avoid the dispute. If you have a dispute, go with the mediation. Singapore Convention is there. Your mediation settlement agreement will be directly enforceable. And for that, as compared to New York Convention, you don't even have to worry about the seat. From which country it is coming from, doesn't matter, because the country's concept is not there. Reciprocity will not apply. Therefore, a mediation settlement happen anywhere, doesn't matter who the mediator, online or offline or in place or out of place, wherever you are, even in a space. You bring it down, you go to the country which is signatory and you enforce over there. So that's the beautiful system now we have. So we don't have to ignore that, we can adopt that in that. And if you want to have more Latin American and Chinese and other, there's a new thing. We have always ignored the mediators' accreditation. If, say, for example, the two countries or two institutions will recognize each other mediators' accreditation, then if Cesar, you are acting as an arbitrator and mediator and lawyer and negotiator in your country, you are the same person. If you are hired as a mediator in China, and if we have a rule that, oh, you have to be accredited in China, then it will be difficult for you to do that. But if I know that you are experienced and we recognize you here in two countries, then you are done. And this one, I have been advocating it through the Legal Services Act, or like, looking at the trade services or free trade agreement and all. Now, European Union, EU and Britain has already agreed. And in that way, say the legal services will include mediation services. So if the legal services are recognized and accredited, then the mediators will be accredited. But what we can do better is that, again, use your position to convince the two sides of the government or the institution to recognize accreditation of both sides. So in that case, you don't have to worry about. And it will be seamless transition of your client from Latin America to China, China to Latin America, no matter what you do. So we can think about something new style and different. And it's quite powerful, it would be there. Even if the mediation fell, at least we can get one thing, is that we will get the parties' agreed facts. We can use these facts in arbitration. We don't have to spend time in going again. We can use these facts and continue, and the arbitration can be faster then.
Okay, great, excellent. Well, Shirlene and Christina, would you like to make any final remarks?
Well, I would just want to thank you all, the ones that are hearing us, and Ming Chao, Shirlene, and Rajesh. I think it was very, very important. Hopefully it's the first one of many that have to come, because there's a lot to discuss. And the best thing would be to meet in person. We just would have to decide where, but but it was very nice. Thank you very much, and thank you, Cesar, for coming up with this event.
Thank you all. It has been a great pleasure. Of course, we are a little late, but after all, we're in this Latin American Chinese thing, and we wouldn't be too Latin American if we were not a little late after all. Thank you so much. It has been wonderful. And as Christina said, I hope this is the first of many other opportunities to discuss these issues and next time together. Okay, have a good day for you there in Asia, and good night, Christina, and see you next time. Bye-bye.
Thanks, everyone.
Thank
Bye.
you. Thank you.
Bye-bye.
Thank you.